Hello, everybody. My name is Stephen Riznyk with San Diego Biz Law, and I am going to explain to you a little bit about our litigation department because it is actually one of my most fun areas of law and one that I have great enthusiasm for. It wasn't the case actually when I was younger. I didn't enjoy it as much, but as I got older, I realized that litigation is a game. It's a game of strategy, cat and mouse, lie and truth, getting out the truth. A lot of things going on in a case, and they're all going on at the same time, and they're parallel. And reading books like Sun Tzu and Thick Face, Black Heart, as well as a number of legal books on litigation strategy, has made this a very fun environment because we like to win, and we like to create a plan that gets us in the position of that for our clients as least expensively as possible. So the purpose of this tape, we have a different one. I say tape, that's, I was involved early on in the industry. The purpose of this video, we have another one that explains the litigation process a little bit, but this one is answering the question, why choose your firm? There are many good firms, all over California that conduct litigation, and we conduct it statewide. But what makes us different is that A, we love what we do. We love litigation. I enjoy the various aspects of knowing that somebody's lying to me or deceiving, hiding the truth, getting it out of them. Two, we're able to resolve most of our cases before they go to trial. For you, the worst thing is to spend all of that money to go to trial. Even if you win, unless you win an enormous amount of money, it's a long procedure and it's an expensive one. For those of you who are aware of our firm, you'll know that I'm a high-level negotiator. I've dealt with politicians, movie producers, actors in areas like extortion, blackmail, career destruction. I negotiate marital issues. So I am a negotiator, and my goal is to get to the other party to a situation where they'd like to negotiate with us. It's not always easy because going into it, nobody wants to negotiate. They're like, yeah, whatever. Then all of a sudden things happen, things change. That's where we add the secret sauce. And then all of a sudden, maybe we should come to the table. In fact, we just had that happen in a recent case where we were dealing with the other side where they had a career um, that is a kind of career where you're used to deceit and lies, things like that. And so they told our client, yeah, whatever. Fine. Well, the good news is a little bit down the road, and we're all already talking close to $500,000. And we're still not finished. But we've gotten to that stage simply because of the tactics involved. So the negotiation will save you a lot of money because some clients don't want to spend a lot of money. But I think the problem that most clients face is the aggravation of litigation, although they don't realize it's our problem. When they leave the office, as one of my coaches said one time, put everything in a sack and leave it here. That's what we tell our clients. It's not their problem anymore, but they are saddled with, attending depositions or answering questions which are called interrogatories or producing documents. I mean, you can't avoid that. But apart from, attending depositions and being at trial, you don't have to go to court throughout the whole procedure. A lot of people don't realize that. But if somebody's wronged you, regrettably, you have to go through this procedure because, obviously you can't do something illegal to get back what you deserve. So the most lawful way of doing it is to, litigate the case. And the good news is there are various phases where you can cut down on your costs of litigation. First of all, sometimes, depending on how stubborn the other side is, and if I think it's strategically a sound idea, so we're all about strategy here, we can send them a lawsuit, fully prepared lawsuit. And we say, here's what you did. Here's the situation. Here's a lawsuit. Can we get down to the negotiating table and discuss this? Or would you like us to file it? Because it's ready to file. We just have to send a check to the Superior Court and it's filed with our service. And some people, although I have to be honest with you, not a lot, but some people will come to their senses or go to a lawyer and see what it costs to defend a lawsuit like that and say, okay, maybe I did do something wrong. Because on a side note, as a negotiator, I will tell you this. One of the biggest challenges you will face in your entire life, it's not winning a lawsuit. It's getting the other party to admit that they did something wrong. Because regrettably, the way our minds are made up, um, our minds believe that everything we do is right. Now, there are times that our minds will acknowledge, like, this is wrong, but I'm doing it anyway. Okay. But when we do everything else, we assume in our minds that we're doing it correctly within the purview of how we look at our world. But the way somebody else's world is affected might be very different. And there's also something called cognitive dissonance, where let's say somebody's working for an employer, working late, they decide they need some office supplies at home. But I'm not talking about staples, I'm like something more expensive. And they take it from the employer's office. Next day, somebody says, this is missing. Do anything about it? No, I don't. They still feel that they're completely honest because their mind has justified it. For example, well, I worked a lot of overtime. I did great work for them. They never gave me a bonus. So therefore, what they did was not dishonest. And under a lie detector, they would actually pass, believing that what they did was not wrong. And this is a big problem. And this is where the issue is very challenging in litigation. Because in negotiation, sometimes that one person admitting that they made a mistake changes everything in such a positive way. In litigation, you're in a different state of mind, and the people don't necessarily want to admit anything. They'll pay you a big check, but they don't want to admit anything. It's a very interesting dilemma. So, phase one, we can resolve some things with just showing them a fully drafted lawsuit. Secondly, some people come to their senses when we file that lawsuit. Now they've got 30 days to file an answer. They have to hire a lawyer, pardon me. The lawyer's going to explain what this case could potentially cost, and they might think, well, I'd rather just pay the other side, get it out of the way, than pay the lawyers. Great. And then third, you've got the people who wait until the courthouse steps on the day the trial begins. So unfortunately, you've got to posture yourself in such a way that you are ready for trial, because you may very well walk in there and not get an offer at all. But very often, you'll find right on the courthouse steps, because they don't want to take a chance that maybe the contract had a provision where they have to pay the attorney's fees if they lose. That would be your fees, so you get a full refund. Or that they have what are called punitive damages, where they're punished for their behavior. And that's where you hear of the massive settlements, million, 2 million, 3 million, 10 million, because they're punitive damages. And those, juries can issue whatever they want, and they can be quite high. The other side doesn't want to take that risk. So from that perspective, resolving a case, my attitude is, if two people can sit in a room, even if you need a bottle of wine, 2 bottles of wine, whatever, and resolve something without going to litigation, that's the best way. Part of the reason I've had problems with litigation is because I don't believe in fighting things out. I believe in resolving it. But human nature, the opposing sides, the lawyers even on the opposing sides, have shown me and clearly demonstrated that reasonableness is a very rare occurrence. And people don't like to empathize and look at things from your point of view. So regrettably, you have to litigate. And so we come in with a very strategic viewpoint. For us, it's a war game. And there are times to attack, there are times to retreat a little bit, times to undergo a diversionary tactic. There are times to create a smokescreen. There are many things that can be done in litigation. And not everything has to be within, having to do with a lawsuit itself. There are many ways of dealing with these issues. And we put them into play when we feel the time is perfect. Because if the timing is not perfect and you execute a plan, it's either going to fail or it's going to warn the other side of what you're up to. So you have to be extremely careful with what you do and how you do it. There are many other things I could share with you today, but I won't, because I don't want it to be public knowledge. What we do is a secret. It's not tremendous secret, but it's what we've developed over the course of almost a third of a century in litigating cases, and we can discuss them with you in your case. We don't handle anything that has a dispute of under 100,000 because, frankly, it's not cost effective for you to litigate something of that nature. But well, I mean, it may be, but perhaps with a firm that is that handles things like that. And on a side note, there are two ways of creating a lawsuit. You can do a form complaint, check off some boxes, put in some paragraphs, or a long form complaint. We don't do the form complaints um, because strategically they're missing so much and they're not the threat they should be. So either do things right, what I consider right being a long form complaint, or you do them fast, and unfortunately you have the risks that go with doing things quickly. And I think that's about all I can tell you right now. If you want to meet with us, feel free, give us a call, discuss your issues. If not, I hope you stay out of court, stay the heck away from litigation. It's truly the cancer of the legal industry in the sense that it's destructive mentally, it's destructive time-wise, it's destructive money-wise. It destroys relationships that have already been created that could have been saved. It's something you want to really avoid if possible. But at the end of the day, sometimes the other party leaves you with no choice. And at that time, you have to choose the lawyer or law firm that's going to best represent your interests that you feel comfortable with. Um, and, um, and I wish you luck in doing that. Thanks for taking the time, and good luck in whatever you're doing.